Yeah, so I'll just start the backup as well.
Thank you. Good morning, everybody, and thank you for coming along to the second meeting of the Ad-Hoc Scrutiny panel of antisocial behaviour. We're going to start we've started the live broadcast, yeah? Yeah, we have. I'm going to ask that if anybody wants to participate to speak, that you put your hand up to speak. We're going to go through the agenda per item, and we're going to invite officers to speak as and when we need to. So first of all, we have apologies. Is there any apologies?
Thank you, Chair. We have apologies from Councillor Davis and Councillor Tolamash, who has indicated he'll be able to join if we become in court at any point, but we have apologies at the moment.
Thank you. Can I ask that the clerk does our roll call, please? Members.
Sorry, can I just say here, it's important as a live broadcast, a very poor show that Labour haven't not only not offered their representative or on this, the last meeting and this meeting, haven't even offered apologies. It's appalling.
Yeah, I do agree with you that the Councillor Gibson should be here today, particularly as he's also Deputy Convener of Housing. But I'm afraid that we were not able to force him to come along. It's his choice not to come along. So can I ask the clerk to take the roll call for members present, please?
Thank you, Chair. Councillor Benison?
Yes, I'm here.
And we have apologies from Councillor Davis. Councillor Flanagan?
I'm here.
Councillor Gibson's not here, I don't think. Councillor McPherson?
Yeah.
And we have apologies from Councillor Tolamash, and Councillor Thompson is here to observe, Chair. Thank you.
Thank you. Just before we start the agenda proper, I'd just like to give a few notes here that I've taken. This is probably something that I should have said last week when I was appointed chair. But first of all, I'd like to express the panel's disappointment that it's taken 2 months to convene the scrutiny panel. A decision was taken in October to form the scrutiny panel, and it shouldn't have taken officers 2 months to convene this panel. So I'd really like to express the panel's disappointment. The first thing that we were told in the minutes in last week's meeting was about time constraints, and we're being time constrained by the length of time it's taken to convene this meeting. And it shouldn't have taken 2 months to convene, and I'd like that point minuted, please. I'm also wanting to note that there's appendices missing from the agenda, the antisocial behaviour review and the allocations policy review papers weren't included in this agenda. As I'm the chair, I didn't see this agenda before it was circulated, or I would have picked this up, and I would appreciate in future if I could see the agenda and the papers before they're circulated. This is an order, the same as every other chair gets to see panel committees and agendas before they're circulated, and I'd also like that point minuted too. Also, there's urgent business. Sorry, Sheila, did you want to say something?
Yeah, sorry to interrupt you there. I'll follow up that point about the papers. I can only say it's probably been because it was produced in quite a hurry to meet the date of the meeting, but I'll certainly follow that up. And it's also just advised, I've just had an email from Councillor Gibson giving his apologies for today.
Thank you. Also, I've noted that urgent business is missing from the agenda as well, and I would like urgent business added to the agenda just in case any of the members wish to raise anything urgently. And a third point, as in the minutes, Dan Hartles has been invited to today's panel to discuss the antisocial behaviour review, and Stephen McCabe has been invited to discuss the allocations policy review. As these papers are not included in the agenda, I'd like to propose that both these papers are circulated now to members of the panel. and we'll take a short recess in order for members to look at the papers, and we can convene again in a few minutes. I had asked verbally at the meeting last week that these papers were circulated again, but they haven't been, and we need them to enable us to proceed with the work that we're doing. So can I ask that the antisocial behaviour review paper and the allocations policy paper is circulated to members just now, and we'll take a recess in order for members to read those papers over. How long will members need to look at these papers? Say 10, 15 minutes, 10 minutes, 15 minutes?
I think that's a good start, yeah.
My only worry about that is I know the allocations policy is quite a significant document, as Stephen Clark will confirm here. And
sorry, Alistair, it's a really bad line and I can't hear you.
I'm sure Stephen Clark will confirm the allocations policy is quite a significant document, and I don't know how many pages it comes in, but you know.
Yeah, it was in the report that was circulated last week, Alistair. So it would be the report that we would need, and it would also be the antisocial behaviour review papers that we would need circulated. Okay. Sheila, did you want to add something?
Oh, sorry, that's a legacy hand, Council, but just to confirm,
No
I wasn't at the last meeting. Are these papers that were circulated for the last meeting, in which case I can quickly email them to you just now, or is this something additional?
Yes, it's just the report that we need, the initial report that we need, and the antisocial behaviour review.
Okay, I'll circulate that to everybody just now.
Thank you. And can we take a short recess for of the members to read through the papers again, just to refresh their minds about it, because they read them last week.
What time would you like to reconvene, Chair?
Okay, we can reconvene at 10:45. 10 to 10. Is that okay with members? Okay, thank you. Thank you. So we'll do another roll call. Sorry. Thanks for joining us again for the scrutiny panel for antisocial behaviour. Can I ask the clerk to do another roll call of elected members to make sure we're all here, please? Thank you.
Thank you, Chair. Councillor Denison,
Yeah, I'm here.
Councillor Flanagan,
I'm here.
Councillor McPherson.
Yeah,
That's the 3 members from before, Chair.
Thank you.
I wonder if I could just mention something before we start, Chair.
Yeah,
I've just checked during the adjournment there, and just to confirm that we can't have urgent business. This isn't a decision-making committee, so there wouldn't be urgent business on a panel like this. So just to clarify that.
okay, thank you. So what we're going to do is we're going to firstly discuss the tenancy agreement of the appendix that's in the papers. And I was going to ask Dan Hartles if he could answer some questions about the tenancy agreement and about the antisocial behaviour review. Is Dan on the call?
Good morning, councillors. Yes, I'm here.
Thank you. Can I ask before officers speak to give their name and titles, just so that members and the public listening are aware of who is speaking? Okay.
Maureen, I think you have to approve that. Have we approved the minutes from the last meeting yet?
Oh, sorry, I forgot. Sorry, Alistair. It's a good job you remember me. So can we go back to approving the minutes of the meeting? Drew, did you want to say something?
No, it was just to point out, Councillor Benison, before the SSTA documents or a housing document, Dan would obviously be here for the ASB, just to maybe split out the two, just for clarity.
Okay, thank you. Right, we'll go back to the minutes because I forgot about those. My apologies. Would anybody like to raise any issues about the minutes? There was something that I did actually want to raise. I was of the understanding that the housing service was going to bring forward some questions for the panel to have a look at and approve. But it's got in the report here that the panel has to decide the questions. Was that the members' understanding as well? Was that other members' understanding?
Yeah, I don't know, Stephen, but that was my understanding, to be honest, Maureen, yeah.
Yeah, thank you. Stephen, do you want to comment on that, please?
Sorry, did you say it was your understanding that members would provide the questions? We do have a draft for you to consider if you so wish, but as I say, it's a draft that could be used for the Engage Stirling platform.
Yeah, it was my understanding and other members' understanding that the service would bring forward some questions for us to have a look at them so that we can approve them to go on Engage Stirling.
Okay, well, as I say, we can show a proposed questionnaire on screen, or we can circulate that to members at the end of this meeting, or we could, we can have a recess later on to review that if you so wish, and we could discuss the question content then. Okay,
we'll take that up after we've did the questions. So would anybody like to propose approval of the minutes?
I'm happy to propose them. Yeah.
I'll second them, Maureen.
Okay. Thank you. So we'll carry on now to speak to Dan Hartles regarding the questions that we have over the tenancy agreement. Dan, are you okay to go ahead with those questions? You ready?
Good morning, councillor. Yes, I'll do my best, and obviously housing colleagues are here as well in terms of anything.
Okay, thank you. So I'll start off a couple of questions I have. On the tenancy agreement itself, it's page 13 of the agenda, 1.8. There's a statement there that says, if you break any of this agreement, we may take legal action against you. Can I ask why it says may and it doesn't say will?
Thanks for the question, Councillor Bennison. Dan Hartle's Community Safety Team Leader. My understanding, and Stephen may be able to assist here, is the tenancy agreement we use is based on a model tenancy agreement from the Scottish Government. So that is the likely answer as to why it will say may. I'm not sure if Stephen or Charlie wish to add anything to that, but that's my understanding. It's a model tenancy agreement from the Scottish Government.
Thanks, Dan. The next question I wanted to ask was 2.7 of the tenancy agreement. It says you must not allow the house to be used for illegal or immoral purposes, for example, dealing in controlled drugs. Can you tell me what the consequences are for a tenant who is found to be or is convicted of dealing controlled drugs or substances? Since the council cannot, to my understanding, evict them, and that's based on legal advice note from council officers.
Thanks, Councillor. So there's always a consequence where somebody is. Sorry, I noticed Charlie's got his hand up. I'll defer to Charlie first.
Thanks, Dan. Thanks, Chair. Sorry, Charlie Haggerty, Legal Manager. So I just wanted to clarify the last point that you made there. There's no point in legal advice say you cannot evict. Legal advice says you cannot have a zero tolerance policy towards drug dealing, but that's entirely different from saying you cannot evict. It is always open to the council to seek an eviction if the circumstances require that, and it's a proportionate response to the behaviour complained of. I just thought that would be useful to clarify that before Dan gives you his response, Councillor.
Okay, thank you. Do you want to carry on with your response, Dan? Thank you.
Thanks, Councillor. Thanks, Charlie. I was going to add what Charlie had said there, that we will always take action. What that action looks like is very proportionate on the individual circumstances of a case. As Charlie's alluded to, eviction is an option that's open. We have to be able to demonstrate it's proportionate and reasonable to do that. But where we are notified that somebody is engaged in any kind of criminal behaviour and they're convicted of that, we will always take action, and that could be sort of a minimum of a final warning, all the way through to considering the other legal options that we've got in relation to action against the tenancy or seeking an antisocial behaviour order, or working with other organisations in terms of, for example, a criminal antisocial behaviour order. So action will be taken. What that looks like, as Charlie alludes to, depends on the individual circumstances of a case, Councillor.
Thank you. It does appear to me that in circumstances where a tenant is dealing drugs and causing antisocial behaviour to neighbouring properties and to local communities, that the decision to impose a policy of zero tolerance against drug dealing is taken out of Stirling Council's hands, because Stirling Council are then bound by legislation from the Scottish Government to not act on the best interests of their tenants. So that's how it appears to me. That's just a comment that I wanted to make. I wasn't expecting a response there. I wanted to go on to page 23 of the agenda, page 3, respect for others, page 3 of the tenancy agreement, respect for others. I'll let you come in a second, Alistair. Thank you. 3.6, if a neighbour makes a complaint of antisocial behaviour, what steps are taken to investigate this?
Thanks, Councillor. Dan Hartles again. So whenever somebody makes a complaint to the council, there's an investigation carried out. Who carries that investigation out depends on a number of circumstances, but primarily it's members of my antisocial behaviour investigation team. If it's complaints about the neighbour, the investigation is quite wide-ranging. It takes a number of factors into account. We will always speak to the person if we've got their details, making the complaint first of all, obtain information from them, and then make further inquiries with partner agencies, other teams within the council, other neighbours, or other people that were affected by, potentially affected by the behaviour. And then we will always go and speak to the other party, sometimes referred to as the alleged perpetrator, before making a decision as to what happens off the back of that. But everybody will be contacted. The only time we can't contact somebody is if they make an anonymous complaint. Obviously, we don't know who they are, but we will still at that point undertake investigations with other people living nearby. That can sometimes be done by a letter drop. It can, pre-COVID, it was done normally by chapping doors, or sending out letters asking people to contact us if they're affected by the behaviour. At which point then we would then go and speak to the person being complained about.
Okay, thank you. Alice, Councillor McPherson, did you want to come in there?
Yeah, thanks, Maureen. I think a lot of today's papers are obviously interlinked, because obviously the point you made about not being able to evict somebody for drug dealing, well, it isn't really the case, because when we look at that social behaviour policy and the streamlined evictions, it makes it very clear there if somebody has a conviction that, you know, they can be evicted. So, and Dan, I think that the question I would like to ask you, and again, it goes on to the human rights, and in a particular case, in fact, I think Brian Flanagan, Councillor Flanagan, raised this at full council when we actually were discussing this about the victims' antisocial behaviour. There was a kind of test case in the minute these papers to get to page 185. I know we're jumping about the paper here, Maureen, but at the end of the day here, it actually makes it very clear here, you know, that this is a residents who were subject to antisocial behaviour. And at the time of writing, the UK failed to respect the right of their family and been subject to appalling violent antisocial behaviour. So my question would be in relation that, you know, this is a complex legal area because it crosses over tenancy agreements, antisocial behaviour policy, and underpinning all that, or overarching all that, we've got human rights. So Dan, go and give us your view on it, or Stephen Clark will give us your view on victims of antisocial behaviour in relation to the paper that obviously we're discussing here, the allocations policy, specifically page 23 and 24. You've been breaching this agreement. So if somebody has been found to be breaching an agreement, explain the process to me.
Thanks, Councillor McPherson. So if somebody is convicted of an offence, or we've got evidence that they've broken one of the tenancy clauses, or you know, sort of engaged in behaviour that we can evidence, we will always take action. As I say, that what that action looks like can vary. The team do operate a person-centred approach at the moment, which is looking very much at what the complainer is saying, taking that into account with any mitigating factors that the other person's saying, but they will always take action in relation to that. There's a policy review, as I understand it, happening next year by the Scottish Government in terms of recommending that a trauma-centred approach is picked up rather than a person-centred approach, but that work is still very much in its early stages. So in terms of if we can evidence a breach of tenancy agreement or criminal offence, that is, as I say, always followed up. There's a meeting with the person who is convicted of the offence. We have to, under the legislation, take account of their views, and we have to be able to demonstrate that in whatever action that we take. You're correct that streamlined eviction process, where somebody is convicted of a serious criminal offence, gives the council streamlined powers according to the legislation, which means that the discretion is taken away from a court. We just have to be able to prove that we followed the correct process. So yes, there are legal framework that we have to follow. but we do always take action in that. I noticed Charlie's got his hand up.
Thanks for that, Dan.
Maureen, can I come back to that scene? Charlie's the only coming in there. Dan, thanks for that. In relation to the streamlined evictions process, I'm not going to ask you to pluck a number out there, but you know, somebody that sits on Environment and Housing Committee and Community Planning and Regeneration, I see the reporting of these figures in the past. So how many streamlined evictions have you carried out in your time in the council, or been part of?
Specifically, my time at Stirling Council, we've not undertaken a streamlined eviction to completion yet. We do have a number that we are considering at the moment with ongoing cases, but since joining Stirling, I've not undertaken any streamlined evictions in this authority.
And how long have you been with the council? Because obviously I know we obviously couldn't evict people during COVID. How long have you been with the council, Dan?
Just coming up on 15 months, Councillor.
Thank you.
Thanks, Councillor McPherson. Councillor Flanagan, did you want to come in?
Yeah, sure. It's just kind of following on with the what's being discussed now. So, if I could just take it to kind of the other end of this. So I was looking at the kind of various policies, including the antisocial behaviour draft policy as well, and just looking at things like standard timescales and response times and all that sort of thing. And I completely understand why there has to be these numbers. But part of the issue that I see is that a lot of this behaviour starts off very small scale initially. Obviously, we get reports of like very extreme behaviour that is, you know, is absolutely abhorrent. But a lot of constituents will contact me and say something like, there's a bike being left in the close, or someone doesn't take their bin out properly, or someone has left something somewhere. And what happens is that this very quickly escalates into abuse and all that sort of thing. And, you know, Dan, you and I have talked at length about different cases that have come up. And part of what I think the issue is that it does take a long time for that kind of immediate reaction. And I suppose what I can understand why it takes a wee bit of time, like 4 or 5 days. But part of the issue that I've got is that when people are calling up the council to say something which is quite low key initially, to say, right, there shouldn't be any bikes in the close, there is a bike in the close, that can sometimes take weeks for anything to happen, by which point the two tenants are now arguing with each other. It's then escalated to abuse. It then escalates to even more stuff. The police get called. The police then say, and again, this is all reports, but the police then say, no, this is the council, contact the council, and vice versa. And before we know it, we're 6 months down the line and we've got a complete breakdown of all relationship in between those areas. So I'm just thinking, could we, is there any thought being given to a kind of rapid kind of, I'm trying to choose my words carefully, but let's call it an intervention where it's very low key, it's not escalated to something that's going to warrant police or reports or things like that. But if if an official member of the council were to go out, like say within 24 hours, that may just de-escalate the situation. Is there anything in place that could kind of do that?
Thanks, Councillor Flanagan. Chair's discretion. I'm conscious that Charlie Haggerty has his hand up and may want to come back just before I answer Councillor Flanagan's question. Apologies.
It's probably best, Dan, if you just answer Councillor Flanagan's. My point was just a point of clarity.
Okay, can I just point out that I'm the chair of this meeting, and I know that Charlie's got his hand up. I can see he's got his hand up, but I'll bring him in when I'm going to ask him to speak. But Councillor Flanagan's asked Dan a question, so I'd like Dan to answer that. Thank you.
Thank you. Apologies. Councillor Flanagan, yes, I hear what you've said there. A lot of work's happened in the last 6 months in terms of how we allocate cases, how the team is set up. We've changed the number of practices within the team. There is a much closer working relationship between my investigation officers, the housing officers, also the local policing team. We are looking at introducing a target within the team to try and resolve issues initially within 30 days. So one of the things that we've talked about within the team is a 30-day response to pick up a case that comes in today, and within 30 days completed our initial investigation and take an initial intervention where required. And that could be a number of things. I've also got a trained mediation officer in the team who was a case officer before. He's been taken off case management and has been solely put into the mediation side for what we call non-complex early intervention. So if you get a case that somebody phones up and says, I think I have a problem with my neighbour, or my neighbour is doing this, then it's in the report is the behaviour that we're talking about, which is unwanted behaviour primarily. He will contact them at an early stage and see what he can do to prevent issues from escalating. We have also, in the policy, committed to reducing our initial contact time from 5 working days to 3 working days, unless a case meets a threshold in terms of a risk assessment for 24 hours. So we are very much, we were working through a backlog. We had some resourcing challenges as we went through last year. The team's fully up to resource now. We've cleared the backlog and the team can respond to new cases currently within 2 working days of them coming in and are engaging with people. So we're in contact with everybody within, on average, 7 working days at the moment. So that's the complainer reaching out to witnesses, speaking to partner agencies, and then also talking to the other party involved as well. So we are absolutely committed to trying to deal with this at the earliest opportunity, because, as you've mentioned, it sometimes does take a long time for people to come forward. People will report issues when they've been going on for 6 months, and then we have to have what can be a challenging conversation around managing an expectation. So people, when they report it to us, expect that we're going to be able to solve the problem in a week or within 2 weeks. But we're having that conversation at a much earlier stage than before, in terms of, right, we will do this to try and assist. This is what we require from you. This is what we will do. But you just need to be aware that this could take some time to resolve. And that answers the question, Councillor.
Could I just come back, Chair? Is that okay?
Yeah, that's fine.
Yeah, so no, thanks for that answer. I mean, I completely understand that there has to be a kind of response times, and there has to be kind of things recorded. So, you know, it's challenging just to kind of respond to stuff immediately. I think the only thing I would ask really is that if there is any kind of way of dealing with it as informal as possible, as quickly as possible, just for these kind of calls that come in kind of initially, that would be a big help, because, as I say, a lot of the phone calls that I get, it's just for people to talk. They have, and again, I know that's not necessarily the use of the service, but sometimes when they just get a phone call from me or someone saying, look, okay, I'll raise this for you, let me get back to you, that sort of thing, that can sometimes take the sting out of it. So, you know, anything we can do to try and catch this before it gets to the kind of behaviours that, you know, we're obviously seeing, the very extreme ones, is obviously a good thing. But no, thanks, Dan.
Thank you. I know that a few years ago, Stephen, you might be able to answer this. The service used to have estate wardens that used to go around, you know, checking things that Councillor Flanagan has mentioned, such as, you know, gardens and keeping, you know, putting bins out and taking them back in, etc. The things that do cause neighbour disputes. Does the service still have estate wardens that undertake this kind of work?
Yes, the service still has 3 estate wardens that undertake this work in and around our estates, you know, dealing with things like fly tipping or, you know, things being collected in a communal stair. So, yeah, we still provide that service.
But you've only got 3 members of staff across Stirling Council area for that?
Yes, that's correct.
Okay, thank you. Charlie, you wanted to come in. Thank you.
Thank you, Chair. Yeah, it was just I wanted to just augment something that Dan said earlier, just to make sure that the members are clear as to what a streamlined eviction can and can't do. Dan's correct in that what it does is it takes away the need for the court to establish a breach of the tenancy agreement. So the criminal conviction itself, the criminal behaviour, is taken as a breach. But what it doesn't do is it doesn't allow the sheriff just to evict based on that. There's still that proportionate argument whether the council moving for eviction is proportionate in all the circumstances. So although it takes away that evidential aspect of it, the council don't have to go there and lead evidence and establish that a breach of the tenancy agreement has taken place, the council still has to prove that the actions that it has taken are proportionate in all the circumstances. So there is still that discretion there to the sheriff to make the decision. It's not automatic. I just wanted to clarify that point.
Okay, thank you. Councillor McPherson, sorry, you wanted to come in.
Charlie, yeah, you're right. And obviously, Appendix 4 of the antisocial behaviour policy makes that very clear. Obviously, I was well aware of the process to streamline evictions. That obviously makes it very clear on page 56, number made by the sheriff and not the council. I get that. Maura, it was the point you made and Brian made as well about the wardens. That's the point I was going to make about the state wardens, but housing officers as well have got a patch too. They've not playing this as well. A simple thing that Brian Flanagan raised there, a simple thing like a bike, that should be a job for a warden or a housing officer to go out there and deal with that very quickly. It shouldn't have to go through Dan Hartle's team for that, in my opinion, because that's my experience in the past. It's a long, convoluted process when you get into Dan's area of work, And I do think there's ultimately they should be separated. And Stephen Clark, my view on this. I've never been comfortable that safer communities is separate housing. To me, it was always historically been a housing function, and this is where the dangers and the crossover and the unfortunate, as Brian said, it can take sometimes 6 months to get things done, But the sooner we can get safer communities back into housing, the better, is the point I would make. Stephen, I don't know if you want to comment on the housing officer role.
Stephen, did you want to reply to that, please? Thank you.
Yeah, in terms of the housing officer role, yeah, I agree that it's perfectly within the abilities of our housing officers to address low-level issues, things like a bicycle or children's toys being left in the close and so on. That's something that they would address and potentially make a tenancy warning for. So it is the sort of work that we'd be expecting to do, and it wouldn't generally be escalated for the antisocial behaviour team to deal with, or if it's things like fly tipping, it would be something reported by an estate warden that we then deal with as well. And in terms of where the service sits, I suppose, in some council areas there is no community safety team. So I think the main thing is that it's great that there's a community safety team, and the fact that it is an all tenure team, does raise some queries from me in terms of why it would be sitting within the HRA funded side of things if it's an all tenure service for housing associations, private landlords and owner occupiers, though I acknowledge a significant proportion of cases will be in relation to Stirling Council tenants.
Okay, thank you. I'm going to turn again to the questions that we were going to ask of Dan from the tenancy agreement, because I think some of the points that's been noted here, these are issues that the tenant has agreed in their tenancy agreement, and the housing officer or the estate warden should be able to go to the tenant and say, you're breaking your tenancy agreement. It's here, you've signed up to this, so you're breaking your tenancy agreement, so you need to get, stop doing whatever it is you're doing. And so I wanted to ask Dan about it says in here, after the investigations have taken part about the antisocial behaviour, it says the tenancy may be changed to a short Scottish secure tenancy or terminated by us. In what circumstances would a tenancy be changed to the SST? And what is the process the council needs to go through to change this tenancy? How often does it happen? And how long is this in place for?
Thanks, Councillor. Dan Hartles again. So, yes, we do use triple STs on a frequent basis. We tend to use them where we've got evidence that a criminal behaviour has taken place or that there's a sustained breach of tenancy conditions. Triple STs initially last for 12 months. They can be extended for a further 6 months where the evidence supports that. That there is quite a robust process that we go through in terms of an extension to a triple ST document. It's reviewed by members within my service, within the housing service, and also within legal services as well. We have to give a statutory period of notice. So at the 9-month point, if we're looking to extend a triple ST, we have to communicate that back to the person. And again, that can be done for up to 6 months. Term of a court process is a legal process. We work closely with our colleagues in legal, and Charlie may wish to add some more about that in terms of the exact process, but it's a court process to terminate a triple ST. The council can't just do that on its own cognizance. Examples of where we would use a triple ST is, as I've talked about, when I look back recently, we've used a triple ST for somebody that was engaged in prolific antisocial behaviour which affected their neighbours. They also at the same time had a number of ongoing criminal matters that we were waiting on a resolution for. So the decision was taken to put somebody onto the triple ST due to the behaviour. And then when we had the outcome from the criminal investigation, we then made a decision about whether it was an extension or a termination. Triple STs do help in terms of trying to manage people's behaviour on some occasions. So again, there was a case recently where we put somebody onto a triple ST off the back of a criminal conviction. It was their first offence. They caused no tenancy problems before. There were no issues with their tenancy whatsoever. And at the end of that, they've reverted back to a secure tenancy, and we've had no further problems since. So triple STs are used by the team in conjunction with discussions with housing and legal services as an outcome. And yes, we will issue tenancy warnings. So we will issue warnings for breach of tenancy on a regular basis. And whenever we do that, we tie in with the housing team and the housing officers as well. And likewise, if they're looking to issue a tenancy warning, they'll tie in with us if we've got a case. So we do combine that into one evidence pool as well.
Thank you. I wanted to ask as well about I've had instances in my ward where there's been persistent antisocial behaviour from the same people. They've been involved. The police have been involved, and they've gone in and out of jail on remand. But the council have had to retain their house for them, and in that circumstances, they've come out of remand. They went back into the council property. They've created absolute havoc yet again. But because of the time that the tenant was on remand, it was as if, you know, well, this person hasn't caused any trouble for 6 months. So the council has kind of wiped clean their antisocial behaviour record, and it's sort of started again. But the only reason that they've not had any complaints about them is because they were in remand. So trying to explain that to my constituents and trying to justify that to my constituents is extremely difficult for me to do, because I know the frustration that these neighbours feel when they see this person going in and out of remand and they're able to keep their house, etc. And all they're doing when they're out of remand is creating havoc in the community. Can you tell me what the council do in that circumstance?
Thanks, Councillor. I may have to defer part of your question to Stephen or Charlie in terms of the tenancy itself.
Okay, thank you. As long as I get an answer, thank you.
Just in answer to one of your part of your question there, we do have to consider the timeframes involved. So if somebody causes antisocial behaviour, there's a record of that, and we can rely on that. It becomes slightly more challenging from a from a court's perspective in terms of the weight that they will give to specific evidence. So if we're going on incidents that happened 12 months ago, the court will not consider that with the same weight that it would consider something that's happened or is happening at the moment. It's what we would call evidential weighting, but we will always rely on that because we talk about behaviour of somebody and show the pattern of behaviour. In terms of remand is quite a challenging one. It's just because somebody's placed on remand doesn't mean there's an automatic conviction of a criminal. There's criminal conviction there, so remand is quite challenging for completely understand the public to maybe understand, and then also how we deal with people on remand. So somebody remanded is not technically being convicted of the offence as yet, which makes it impossible for the council to rely on somebody being proven guilty of an offence. Again, we would look at what options were there. But yes, I completely accept the position that when they're on the remand, they're not there causing problems. But we do still consider their previous behaviour. So we will always make a case in terms of pattern of behaviour when considering any outcome, be that warning or be that legal action. Not sure.
Okay, thank you. Stephen, did you want to add anything to that?
No, I think Dan's fairly well summed it up there. I don't know if my colleague Stephen McCabe wants to add anything to Dan's comments either.
Thank you. Stephen, did you want to add anything?
No, I don't think so, Councillor Benison. I think Dan's covered that off. Okay, thank you. I've no doubt that I knew Alistair would come in there. Thank you.
Not to disappoint you, Maureen. Yeah, Dan, I think the whole purpose of this ad hoc scrutiny panel, and obviously I heard when Maureen raised it, Phil Kearns and Brian discussed, and I discussed it as well, and I must say, I've never seen I was complacent as Deputy Chair of Housing and a former Chair of Housing. I actually think I thought that we'd actually dealt with it okay, but I don't think things have improved over the years. I think things have got worse, but probably because legislation's trying to give more rights to tenants. But and Dan, I really want to focus on, and I said that I had an analogy at the last meeting that you weren't there. There's a piece of string or a bit conduit pipe. You know, at one end you've got the complainer, the other end you've got a sheriff, and as an elected member, we see the complainer hounding us. And Brian mentioned it as well, and I know Maureen gets it, and I get it. And ultimately, our sheriff throws it out if it isn't done properly, if it isn't structured properly. But in relation to streamlined evictions, I really want to do focus on that here, because ultimately that gives us the power. And I know in a number of cases that people have been given a custodial sentence, and we haven't evicted them. And I'm reading here in Appendix 4 on the document here in the review of the policy, and I'm jumping about here. It says, in certain cases where there's been a criminal conviction punished by imprisonment over the last 12 months, basically gives us the power, again, as Charlie said, if there's the evidence to back it, it's a simplified process. So I'm really keen to focus this on the streamlined evictions, and maybe Stephen Clark would want to say more about it, or Dan, what are certain cases where a criminal, so what are the certain cases where we wouldn't go for eviction? Nobody wants to pick that up.
Yeah, I mean, it's Stephen Clark here. I think it very much depends on the case. I'm not sure if Charlie wants to provide some examples potentially. It's difficult for me to answer that question just because it is very dependent on length of sentence and other circumstances.
Okay, Charlie, do you want to pick up on that?
I've not really anything. Thank you, Chair. I've not really anything to add to what Stephen has said. It's very difficult to think of things in the abstract, and these cases are looked at or should be looked at on a case-by-case basis as and when they arise. And it very much depends on the offending, where the offending took place, whether the offending harmed other individuals. I mean, I know, like, just from the top of my head, some of the case law around streamlined evictions, relates to the proportionality of the action which was taken. And in the context of the two cases that I can think of, one of them was a gentleman who was growing cannabis in the tenancy for his own use. And that, if he'd never been in any tenancy problems beforehand, and the sheriff, I think that one was in Glasgow Sheriff Court, found that eviction was a disproportionate response. It could have been dealt with in a different way. So again, you know, it's all contextual, councillor. So it's very difficult for officers to say, in these cases, this is what we would look for, because you have to just look at each individual context, and that's the whole issue, which I think is the nub of what you're getting to, which is the proportionality argument. Proportionality is subjective to an extent, because it depends very much on the factors around the convicting. And that is what officers would need to look at when coming to the decision whether to proceed with an eviction or not.
Okay.
Sorry, Maureen.
Alistair, I was going to suggest that what we should do for the next meeting is bring forward a paper on streamlined evictions and how other councils deal with streamlined evictions. There must be examples of it.
I don't have any issues with it at all, Maureen, but I think at the end of the day, there's certain cases, this beggar belief, Stephen Clark's a experienced chief housing officer, right? And somebody's a previous chief housing. I would expect, and there was, whether people like it or not, a zero tolerance policy previously to drug dealing, not for personal use. So that was probably a practice rather than a policy. Yeah. That, you know, and Charlie's obviously, there's a brief note here from Julia about, you know, it would be unlawful to have a zero tolerance policy. I get that in the context of the law. However, the certain cases under streamlined convictions, I really want to drill down it, because quite clear the discretion there for our officials to deem certain cases where it would be right to evict people who have been punishable, be punished by a prison sentence. So what are these certain cases? A really important matter for me. Thank you.
Thanks, Councillor McPherson, and that's why I'm asking that a specific paper is being brought forward to the next meeting on streamlined eviction, so that we can actually drill down on the issues that you've raised, because I do know that Stirling Council used to have a policy a number of years ago, and it was a zero tolerance policy regards people who were tenants and they were convicted of drug dealing from council tenant properties, and Stirling Council brought in a policy of zero tolerance, but then they were told that they weren't allowed to have this policy, which is why I was of the understanding that you weren't allowed to evict someone who had been convicted of dealing drugs from a council tenancy, because we seem to get conflicting evidence, conflicting opinions from officers at times on this issue. So can I ask the clerk to note that we would like a paper brought forward on streamlined tenancies, please, so that we can ask specific questions about that issue for the next meeting. Are the members happy with that? Alistair?
Thank you.
Yeah, streamlined evictions, Maureen, yes, absolutely. If there's any further information, I've got a briefing here, but
that's fine.
Very important information, that'd be great.
Yeah, Councillor Flanagan, are you happy with that as well?
Yeah, I'm completely happy with that. Yeah.
Okay, thank you. I wanted to go on, and I'm still on the tenancy agreement papers here. On 6.3, it says by court order, page 39, it says you or someone in your house has been guilty. Does that mean guilty by a court of law, or is it guilty by evidence found by Stirling Council? And what is the level of evidence needed to prove guilt? It's 6.3 of the tenancy agreement. Charlie, if you can answer that, please. Thank you.
Sorry, Chair. Could you just remind me what page it is you're looking at, what paragraph? 6.3?
6.3 of the tenancy agreement, and it's page 39 of the agenda. And it says you or someone in your house has been guilty. And I'm asking, is that guilty by a court of law, or is it guilty by evidence found by Stirling Council?
The heading for 6.3 is by court order, so that would be guilt by the sheriff, and the evidential requirement there is beyond reasonable doubt.
Okay. So it would be from a court of law. So and it's saying it's appropriate to transfer you to another house. So basically that's just moving the problem to another community. So is there any other course of action available to the council rather than moving one person who's committing antisocial behaviour in one community to another community? Stephen, do you want to answer that, please?
It's not always the case that the council would move someone to another property. It may be that we assess them as making themselves intentionally homeless by dint of their actions. And if that was to happen, we would be able to provide housing advice and options advice to someone that's been evicted, but we wouldn't be providing them with an offer of housing because we would have judged them to be intentionally homeless. That's an example of what could happen.
Okay, thank you. Is there any other questions that any of the members want to ask Dan?
No.
No. We'll move on now to Stephen McCabe and some questions that we have for him. Oh, my apologies, but we're going to ask Dan questions about the antisocial behaviour review. Does anyone have any questions on that?
Well, I think I've answered mine because inevitably they kind of crossed over with the tenancy agreement. I think all these papers are all interlinked,
Okay. So we'll move on now to questions for Stephen McCabe, and that's questions from the report that was circulated last week. Can I just check that Stephen's still on the call?
Yep, I'm on the call, Councillor Bennison. Thank you.
Yeah, thank you. And can you give your name and your title before you answer questions, please? One of the questions that I wanted to ask on 2.4 of the report that was given last week, it's stated that it seeks to support and risk assess the current situation, and that points may be awarded based on antisocial behaviour affecting their health. Can you tell me in what circumstances a person would get points for antisocial behaviour to enable them to get some extra points on the housing list to get them a move away from the area that they want to move from?
Thanks. Stephen McCabe, I'm the Housing Allocations Team Leader. So there's no specific points that are awarded for being the victim of harassment or antisocial behaviour just now, Councillor Bennison. What can happen just now is if a person is experiencing antisocial behaviour and that's having an impact on their health, if it's having an impact, for instance, on their mental health in particular, then we can assist them to apply for medical points as specified through our allocations policy just now.
Okay, thank you. And on when the review of the allocation policy was taking place, 2.7 said that 60% of respondents agreed from the tenant working group that antisocial behaviour was a reason why people should receive points to enable them to move property. You may not know the answer to this, but can I ask, had any of these tenants who had answered this actually experienced harassment or abuse from neighbours?
It's not something that we would know, unfortunately. The respondents were all anonymous, so we wouldn't know.
Okay. 2.8 says that you've agreed a 12-month review, and then it seems to list some reasons why a 12-month change in the policy within 12 months isn't recommended. What I would like the Housing Service to do is to use this 12 months to work on how corroboration is evidence from other councils, because I do think it's important that if tenants are experiencing antisocial behaviour and they want to move, that they have as many points as possible to enable them to move away from the area. And so what are the service doing in the 12 months to review this? What's going to take place to review this policy?
So the intention, Councillor Benison, is that we will start looking at the review early in the new year. We've already spoken, and the Stirling Tenants Assembly have asked that we review and look at the potential for adding harassment points into the policy at the annual review. So it is something that we were already considering. So early in the new year, we will look at what areas of the policy we want to look at within the annual review. There is a legislative duty on us to consult on any changes that we make to the allocations policy, so we will have to do some form of consultation. The level or the form that takes depends on the changes that we're proposing. It has to be commensurate with the level of changes that we are proposing. It may be, if it's slight changes, that we can just consult with tenants groups. It may be that we put something and put questions up on the Engage platform as well. But we'll start that work early in the new year.
Thank you. How many councils across Scotland have a policy where their tenants are allowed points for antisocial behaviour? Is Stirling one of a few that don't do that, or is it normal practice that antisocial behaviour doesn't get extra points?
It's mixed, to be honest. We looked at this and done a quick review of allocations policies a few weeks back, and around half of local authorities have points for antisocial behaviour and half don't, so it is fairly mixed.
Okay, thank you. Councillor Flanagan or Councillor McPherson, do you have any questions for the officer? Councillor McPherson.
Yeah, well, I take it that I'm just, my door went there, so apologies, that's part of the problems of working from home now. I take it we're talking about here on the allocations policy. It was emailed to us on the 10th, a review of policies associated with housing and social behaviour. The 10th of December policy, is this the one we're discussing just now? Yeah.
Yes, it is.
Okay, that's fine. I think the only questions I would have on it, Stephen, and I know that the challenges they've got with allocation and such, like, I think the real challenge is there. Everybody knows that, but I think it's what I've found in the past is obviously lifestyle clashes where you've got maybe a block of 4 flats and there's 3 elderly people in it, and I think the cases that I had in Flynn and Terry. And then we could put somebody in there, a young family, a single person in there, and they create absolute havoc. And so do we still have a sensitive letting policy for occasions like that? It's lifestyle clashes and closes.
Yeah, I think you're absolutely right, Councillor McPherson. There can be issues of lifestyle clash when we allocate a person a property if it's 2 completely different lifestyles that neighbours might have. And sensitive lets is again something that we're intending on looking at adding into the policy, or suggesting that we add into the policy at the annual review, just to kind of give a bit more information about some of the other things that we can potentially do as well. There's certain other changes that we might want to look at within the allocations policy as well, one of which is potentially extending the suspension reason for, or the suspension length for people who have been convicted of antisocial behaviour. Just now, people are suspended from the housing list for a period of 12 months. Legally, we can potentially increase that up to a maximum of 3 years. So it may be something that we want to consider as well.
Molly, can I come back to this? Stephen, it concerns me really. That was always the policy, again, whether it be a practice or a policy in the past. And I hate to keep going on about the past, but at the end of the day, the sensitive letting policy was not just lifestyle clashes, it was people who had actually been convicted in the past of convicted of criminal offence, and then they came through the homeless route and through time. They were then given similar case of a workman in Barrett, Maureen, you and I, and they come through here without being specific about any case, but they come back through the system and they're put back into a shared block flats, and then they start to create havoc again. So I think, it surprises me that we don't have that sensitive letting policy in place just now. It really surprises me. Stephen,
Yeah,
was that been taken out in the past, or was it just maybe a practice rather than a policy?
It's not been in the allocations policy, certainly not from the time that I've been within housing. So it's not been in the allocations policy from the last review, which was done in 2010, I think. So that there's been no sensitive let policy since then. I think it might have been in the allocations policy before that, Councillor, but I'd need to go away and double check that.
Oh, you're probably right, Maureen. I think at the end of the day here, what we found there were people, if it was a block of four, I know there's certainly a block of four, a person was evicted because of antisocial behaviour, and then they would allocate that to somebody not as challenging, shall we say, rather than putting somebody else in who is challenging. That was part of the sensitive letting as well. It really played an important part of that.
Thank you. Councillor Flanagan.
Thanks, Chair. It's more of a just a question. I don't know if this is a silly question or not, but so once the tenant signs their agreement, sorry if we're kind of jumping about, but once the tenant kind of signs their agreement, does that mean that that's where is that now the law now well and truly enforced at that point? There's no, for example, just the description that Councillor McPherson just gave there. So they've signed an agreement to say that everything will be absolutely fine. You won't hear a peep out of me. If that behaviour was to start, say, within 12 hours of them signing their agreement, is it a case? Again, I'm trying not to compare it to something that's nothing like it, but would they now have the full protection of the law immediately after signing their tenants agreement, or does the council have an option within, say, a month of that agreement being null and void effectively?
Thank you. Charlie, did you want to respond to that, please? Thank you.
Thank you, Chair. Councillor Flanagan, yeah, when it's signed, it's in force and enforceable, so there's no kind of cooling off period or any equivalent like that.
Yeah, and again, the reason I was asking was kind of twofold to that there as well. That again, I don't want to say that this would ever happen, but it might be a case that there was maybe something overlooked or something like that. So even if there was an administration error in someone being allocated somewhere or something like that, or for example, if the person is there, in fact, you've answered my question.
Thanks, Councillor Flanagan. Stephen, did you want to come in?
Yes, thanks. Just to say that I do think that at one point there was legislation being looked at by the Scottish Parliament in relation to the use of probationary tenancies for a period of time. I don't think that was taken forward though, but we can do a little bit of digging and researching into that as to why that wasn't progressed. But I think at one point that was being looked at. I'm not sure if my colleague Stephen McCabe could elaborate on any more of that, but I do recall it being looked at a number of years ago.
Sorry, Stephen McCabe, did you want to add to that?
Yeah, just to say as well, I do remember that the Scottish Government were looking at that, Stephen, and I think there were some concerns about potentially reducing the rights of council tenants. Seems to stick in my mind about that, but I don't know where it went. Something we can definitely look at.
Thank you. Does members have any other questions that they would like to ask officers?
Plenty of comments.
Yeah, Councillor McPherson.
Plenty of comments, to be honest.
Yeah. That was my next question, Alistair. Would you like to make some comments?
Yeah, and obviously, as I say, it's quite a difficult meeting is because all these papers are interlinked, as I keep saying here. But I must say, and this is no criticism of the officer, because this is a COSLA document I'm reading here, obviously promoting positive outcomes. And it's, son, I actually sat and read this morning, over 100 pages, and I thought to myself, geez, that's really good stuff, eh? But see, at the end of the day, what they don't actually say, I could, over the 15 years I've been a councillor, and I would like to see the other side, the flip side of the coin here, because all this sounds great, but see, and the harsh reality of the matter is that our casework is full of the antisocial behaviour, and we don't seem to be able to take an action, and these promoting positive outcomes, a lot of this stuff is utter nonsense, to be completely blunt here. It just doesn't work in practice, and that's no criticism because it's a COSLA document, nothing to do with officials. Our officials, our hands are tied to a certain extent with legislation. But I think, and I said it at the last meeting morning here, that if this ad hoc panel is going to achieve anything, I keep reverting back to this, it's where we've actually gone wrong in the system. And so that's what we need to explain to our constituents who, I'm not saying about none of them actually viewing this today, but I'm more interested in the failings here, how we can't get people who are creating havoc in communities evicted. That's all I'm interested in this here. And I've always taken a zero tolerance towards eviction for rent arrears because it's a poverty-related issue. And people might say this is the same, and I get that, but we should never underestimate the blight in communities caused by antisocial behaviour. And we take it underneath why we can't be no better at it, but we can't evict more people.
Thank you, Councillor McPherson. Councillor Flanagan, did you want to add any comments?
No, I think I've said everything.
Thank you. So I'm going to now go on to the Engage Stirling questionnaire. What I would like officers to do for us for the next meeting is to bring forward some questions that they think would be suitable and appropriate to put onto Engage Stirling, to engage with our tenants and with our communities. So I'd appreciate if the next meeting the questions could be ready so that they can be put up and engage as soon as possible after the new year. I'd also like a paper on what was the term that you used, Councillor McPherson, the paper we agreed we would have, because I didn't write that down.
Streamlined evictions.
Streamlined evictions, yeah. Thank you. I'd also like a paper on streamlined evictions so that we can concentrate on asking questions around that, and about the sensitive lets that Councillor McPherson was talking about as well, and the officers were talking about as well. I'd like a paper on that as well so that we can ask questions on that to find out if that's something that would help the situation at Stirling, and if that's something that we could implement at Stirling as well. As elected members happy for those three papers to be brought forward?
I'm happy with that.
Yeah. Bryony, did you want to come in?
Thank you. It's Bryony Monaghan, Interim Head of Education, Independent Officer for the panel. It was just to say that we have had discussions about the Engage process between the last meeting and now, and as Stephen Clark mentioned earlier on, there is available now a draft suggested set of questions that could be considered today so that we could move forward with that if it was acceptable or something similar was acceptable.
Would it be possible for those questions to be circulated to all the members? Because as you know, all the members aren't present today, and I think it would be helpful if all the members involved were able to see the questions rather than it just being 3 people deciding yes or no that these are okay. Does the other members agree with that?
Yep.
So would it be possible for the questions that you've prepared, as you've said, to be circulated to all the panel members, and we'll get back to you with our response, and then we'll be able to confirm at the next scrutiny panel meeting if we're happy with those questions to go ahead. Okay. Right, thank you. Sorry, Charlie, you wanted to add something?
Thank you, Chair. Yeah, it's just asking for some clarity around the paper you're looking for on streamlined evictions. There is a briefing paper which I think was produced in with the documents at the last meeting of the panel. Are you wanting something in addition to that? And if it is, could you maybe just let us know, because obviously we'll need to look at augmenting that if it's something over and above that you're looking for.
Morning,
Yeah,
can I
we
come
can
in
do
there,
that,
Mr.
Charlie. Alistair, did you want to come in?
Yeah, but Charlie, the Scottish Government's issued guidance on the 1st of May 2019 on it, and there's a 15-page document on it for the Scottish Government. And streamlined eviction process, criminal or antisocial behaviour, statutory guidance for social landlords. I would like to see that, and like to see how we adopted the full guidance on that, or we've only obviously issued a briefing note, so I need to see how that Scottish Government guidance actually works in the Council's governance process for housing.
Thanks, Councillor McPherson. Did that answer your question, Charlie?
Thanks, Chair. Yes, I mean, I'll speak to Stephen about that, and Stephen's team, and we'll see whether that actually has fed into the briefing note already, and we'll let you know that. I just wanted also to check. I think there was some mention earlier of how others are doing this, and we can try and get some comparators. Maybe not be able to get all other 31 authorities, but we'll see what we can do.
Yeah, that would be helpful. Thank you. Now, is there any other comments or questions members would like to pass? Alistair, your hands up.
Apologies.
That's okay. So are we happy to end the meeting?
Yeah.
As it is just now? And are officers clear on the papers that's to be sent to the next meeting? Right. Sheila, do you want to come in there? Thank you.
For the next meeting, yeah.
Thank you, Chair. That's just what I was going to suggest. Obviously, we'd have to look at diaries, and I'm assuming that members would like the next meeting as soon as possible. That's the bit, the most we can say at the moment until diaries are
yes, as soon as possible after the new year.
Okay.
Yeah. Thank you, and thank you very much for coming along to our meeting today. And I'd like to wish everybody a happy Christmas and have a very restful couple of weeks off. Thank you.
Thanks, Chair. Merry Christmas.
Thank you.